Welcome back to our course on the AI Act. In part 6.1, we focus on regulatory sandboxes under the EU AI Act, what they are not, and why they matter for innovation and enforcement, as well as regulatory learning. The main topic therefore revolves around sandboxes are a governance instrument in the AI Act's measures in support of innovation. They are designed to let providers and authorities test AI systems under supervision and in cooperation with each other, with a defined plan, boundaries, and obligations before market entry. So, why do sandboxes exist in the AI Act and what do they enable? They exist because the AI Act is enforceable only if requirements can be translated into operational practice. Test methods, documentation routines, monitoring, and corrective action. Sandboxes give authorities and providers a controlled way to co-produce compliance and knowledge for AI Act compliance and regulatory learning to enforcement. They also have a market design function. They can reduce uncertainty for providers, especially small and medium enterprises, by clarifying what evidence regulators will expect and how to structure compliance work before placing a system on the market. Here's the structure of what we do in this segment. First, we explain experimental regulation as a technique. We connect sandboxes to data protection because AI testing often involves personal data and institutional oversight questions. We ground everything in the AI Act's legal regime, especially the relevant articles 57 and 58. And we end with governance constraints, capacity, selection, and coordination. The key point is that the regulatory technique itself matters. Sandboxes are one way of answering the moving target problem. Rather than waiting for the perfect rules and perfect enforcement capacities, which are unrealistic anyway, authorities can supervise bounded experimentation to learn what safeguards and evidence are workable. But the rule of law limits are and should remain crucial. The AI Act frames sandboxes as structured and supervised, not as a reason to reduce legal boundaries wholesale. The design challenge is flexible but effective. Innovation supports without weakening fundamental rights protection. At least this is the idea in theory. Tech is fast, law is slow. The AI Act sandbox logic is linked to the executive competent authorities and supervisors as a source of knowledge generation. So sandboxes aim to improve not only products but also legislative and enforcement practice through evidence from supervised testing and clearer expectations for compliance work in relationship with the deployers and providers. Sandboxes connect empirical insights with legal and judicial aims by collecting data and evidence within the scope of regulation. Limited timeframes, restriction to protect certain goals and protected areas are captured in their clauses. Enforcement techniques often associated with sandboxes, which were originally developed in the domain of social science, are legal laboratories as temporary test spaces. Sandbox pioneers. This is where we briefly contextualize. Sandboxes have been used in other areas, not only AI regulation. Fintech, data governance, health innovation, to manage uncertainty in these highly regulated markets. That is also why the AI Act built sandboxes into an EU-wide innovation support chapter rather than leaving them as purely voluntary experiments to the member states. Sandboxes are treated as a governance instrument that should align with enforcement and compliance pathways, not sit outside them. Now we move to the legal anchor. Article 57, paragraph 5 describes a controlled environment that fosters innovation and facilitates development, training, testing, and validation of innovative AI systems for a limited time pursuant to a specific sandbox plan, which has to be agreed on with the competent authority. Two things matter here. First, the sandbox is plan-based. Participation is not informal. There's an agreed plan that structures what is tested, under what conditions, and with what safeguards. Second, Article 57, paragraph 5 explicitly allows real-world testing within the sandbox, but supervised. But the AI Act itself does not define what counts as innovative. Shaping this understanding is left to the implementing acts of the Commission under Article 58 and the experience in practice. The goals of the AI Act sandboxes, and these goals aren't just rhetoric. Article 57, paragraph 9 functions like a policy mandate for what sandboxes should deliver in practice. The first goal is legal certainty for compliance, not only with the AI Act, but where relevant, also with other applicable union and national law. Operationally, that means a sandbox should help providers turn vague or unconcrete obligations into concrete artifacts. What documentation is expected, what test evidence is credible, what monitoring is necessary, and how a safe deployment plan looks like. Second, the AI Act explicitly wants sandboxes to support sharing best practices through cooperation with authorities. This is important because compliance isn't only technical, it's also procedural. How do you organize risk management, human oversight, logging, incident handling, and internal accountability, for example? Sandboxes are meant to standardize these practices through guided supervision. Third, sandboxes are framed as innovation policy, fostering innovation and competitiveness and facilitating an European AI ecosystem. The key point is that the AI Act is trying to avoid a binary choice between innovation and regulation often present in the political discussions. Instead, it creates a supervised pathway where innovators can test while staying inside enforceable boundaries. And finally, this slide emphasizes on SEMs and startups. This directly aligned with the AI Act's intent. Sandboxes should make compliance feasible for actors who don't have large legal and compliance teams. In practice, a well-run sandbox lowers entry costs by providing templates, procedural clarity, and regulator feedback early before a system is placed on the market. Equally important is the goal of evidence-based regulatory learning. The AI Act is designed so that sandboxes operate within regulatory supervision, not outside it. That's exactly why the detailed arrangement matters. Article 58 is about setting uniform rules through implementing acts by the European Commission on how sandboxes should function within them. So sandboxes should be open to eligible providers and selection criteria, and processes should be transparent and fair. Article 58 also pushes for administrative predictability. For example, it includes procedural expectations like informing applicants of decisions within a set period. However, the AI Act wants predictable procedures, but capacity constraints can lead to uneven implementation if these rules are not resourced. Thank you for watching our first part of regulatory sandboxes. We are looking forward to welcoming you back on our second part on regulatory sandboxes.